In this voice thread, I'm going to cover two topics. One is government speech, and the other is hate speech. Again, to clarify, just so I'm not confusing anybody, there is no hate speech area of exception to First Amendment protections in the United States, right? So hate speech is not punishable. Now, that said, there is still an area of speech that's referred to as hate speech. And the reason for this is that this periodically comes up, right? So there is some political will behind making hate speech an area of exception. So we have some sort of like theory and conceptualization of what hate speech is. We're going to talk about that in this voice thread. And I'm also going to discuss government speech. So I'm not going to spend a lot of time on government speech, but it is a sort of odd little area of First Amendment law that I want to bring to your attention because it has some importance in terms of how we actually think of First Amendment rights as something that mediates between citizens and government. All right, so we're going to cover those things and some cases in this voice thread. I want to begin by asking the question, does it make sense to think of the government as a speaker for First Amendment purposes? So periodically in the cases that you've been reading and in these voice threads, there will be some sort of reference to like the purposes of the First Amendment. Well, what are the purposes of the First Amendment? Like most of the Bill of Rights, we could reasonably think of the First Amendment as being a provision in the Constitution that is supposed to outline the limits of what government can do kind of to citizens, right? The limits to the kind of like interference or restrictions that government actors can put on citizens. Well, then does it make any sense to think of the government as possessing First Amendment rights? There's an area of the law that deals with this. It's a relatively new area because, until the last maybe few decades, the court just assumed that the government doesn't have any First Amendment rights, right? For that same reason that I just raised, which is to say, the government doesn't seem like the kind of entity that needs protection from the government. Now, that said, we do have something now that is referred to as the government speech doctrine. And this has arisen from a number of cases that have come up. So, like I said, I'm not going to say a lot about this, but I will give you the basic outlines. In part because it ends up being important for cases that look like they maybe should be decided by other parts of the law. Specifically, I'm going to talk about Pleasant Grove versus Sumum, which looks an awful lot like a freedom of religion case, but gets decided as a government speech case. And then we're also going to look at Mattal versus Tam, which we might think of as a hate speech case, but also gets decided as a government speech doctrine case. All right. So the basic idea here behind the government speech doctrine is that it has its own rights as a speaker. When the government speaks in its own voice, it can assert its own ideas and it can promote its own messages, free from the normal First Amendment restrictions that require that the government not engage in viewpoint discrimination. So to clarify, when the government is talking about its own actions, its own priorities, its own policies, it is permitted to indulge in viewpoint discrimination. Well, that seems weird, right? Isn't the First Amendment supposed to keep the government from, like favoring one viewpoint over another? Isn't that what they're doing in all of the rest of the areas of First Amendment law? Yes, right. So this is kind of one of the internal tensions with the government speech doctrine. So on the one hand, this seems very bizarre because it violates one of the bedrock principles of freedom of speech, which is that the government should be viewpoint neutral. However, the justification for the government speech doctrine is that, the government is elected. We have representatives, they speak for the people. And one of the things that the people want the government to do is take positions on certain policies, right? We vote for politicians who promote one policy and not another for a reason. So once those people get into office, they can't really do their job unless they have some capability for showing favor to their own policies. So that's the rationale for the government speech doctrine. As far as how we see government speech appearing, there are a few different contexts. In one, it is government as employer, right? And so that governs what people who work for the state can say and cannot say in their capacity as state employees. Your book touches on a few of these cases. I want to also point out that the discussion question that I posted about Officer Abbott would fall under this, right? So the government speech doctrine says that the government can, engage in viewpoint discrimination when it speaks in its own voice. So Greg Abbott making this racist comment, right? Or I don't know if he thought it was a joke or what, but this completely racially insensitive, totally inappropriate comment. He's speaking on behalf of the government as long as he is a state employee performing his duties. So according to the government speech doctrine, the government is perfectly within its rights to say, no, this is not the message that we want conveyed to the people on behalf of the government. So sorry, Officer Abbott, your career is over. All right, so there's the government as employer, but there's also government as funder, right? So what the government does fund, what the government doesn't fund, we'll see some more gray cases there in terms of viewpoint discrimination, right? So what kinds of policies can the government refuse to fund without sort of like edging into maybe more questionable areas of viewpoint discrimination. And then finally, sometimes the government speech doctrine is invoked in the context of the government as educator, right? So this is the case of public institutions of education, be that elementary schools, K through 12, or institutions of higher learning. So I'm just going to talk briefly about a few of the kind of highlight cases in government speech. First, we're going to look at the government as funder. So this case from 2001, Legal Services Corp versus Velasquez, deals with the First Amendment rights of attorneys working for the Legal Services Corporation. So I'm not going to just kind of read everything on the slide. So I encourage you to look at the slide. It has all of the facts on there. But I am going to talk about like the major issues involved with this case. So this dealt with congressional funds being appropriated in this case, right? So generally speaking, Appropriations Act from 96 to 2001, Congress had prohibited the Legal Services Corporation funding to go to any organization that represented indigent clients who were challenging, essentially, the standing welfare laws. So this puts these attorneys in a very difficult position, right? So the ethical code of their profession obligates them to do to the best of their ability to represent the interests of their clients. Well, they represent indigent people. And sometimes they're representing indigent people who are challenging decisions made about welfare law, but also sometimes these cases presented a challenge to existing welfare policy. And so denying funding to this corporation potentially violated the First Amendment rights of the Legal Services Corp attorneys. So the legal question that comes out of this is whether the funding restriction that Congress put on the Legal Services Corporation, so this restriction prevented attorneys from representing clients who are attempting to amend or challenge existing welfare law. So does that funding restriction violate the First Amendment? Ultimately, the court said yes. Now, this was not a slam dunk decision. It was a 5-4. So Kennedy wrote the opinion, but the court held that this funding provision limited significantly the kinds of arguments that the Legal Services Corp attorneys were allowed to make on behalf of their clients, right? So again, on behalf of their indigent welfare recipient clients. So what the court found was that this restriction violated the First Amendment because it regulated private speech, right? So this is communication between the lawyer and their client. So Kennedy said that the legal services program was designed to facilitate private speech, not to promote a governmental message. And so he said that this was a case in which it was inappropriate, right, to apply the government speech doctrine and argue that, yes, the government could restrict this funding on the basis of promoting or not promoting a particular viewpoint. And so, as I said, this was not a unanimous opinion by any stretch of the imagination. It was a 5-4 decision. And Scalia wrote a dissent in which he was joined by Rehnquist, Thomas, and Sandra Day O'Connor, arguing that this wasn't, and I quote arguing that the Appropriations Act, and I quote, does not directly regulate speech, that it neither establishes a public forum nor discriminates on the basis of viewpoint, end quote. So this is a sort of hotly contested case. But in this case, the court found that the government speech doctrine did not authorize Congress to include this restriction on the kinds of topics that that one of these attorneys could discuss with their client. As an aside, the full decision of Legal Services Corp versus Velasquez does make reference to this case, Rust versus Sullivan, which is the case that established the government, that sort of codified the government speech doctrine. So here they repeat that although the government has the latitude to ensure that its own message is being delivered, neither that latitude nor its rationale applies to subsidies for private speech in every instance. Okay, so the key fact with Legal Services Corp versus Velasquez was that this funding was contingent on restrictions on what the court is seeing as private speech taking place between an attorney and their client. So keep that distinction in the back of your mind as we move on to the next case. We're going to take a step back in time now and look at Rust versus Sullivan, which is a case from 1990. So this is the case that is cited in Legal Services Corp versus Velasquez. I wanted to do Velasquez first, though, so that we could outline the reasoning that the court used there. So as you'll recall, the concern was that the restriction that Congress put in place limited the private speech that could take place between the attorneys at the Legal Services Corp and their indigent clients. And so for that reason, the court found that the speech at stake in that case wasn't subject to the government speech doctrine. Now, Rust versus Sullivan is in some ways very similar, but ends up being decided differently. So what happened here was a case dealing with Title X funding, right? So this is congressional funding, right? Federal funding that the Department of Health and Human Services gives people, but it goes with regulations, right? So it's issued to healthcare organizations, but there are restrictions that go with it. And so specifically, there was federal legislation limiting the ability of Title X fund recipients to offer abortion-related healthcare services. So the Title X funds could be used for preventive family planning services, but no discussion of abortion, no provision of abortion, no referrals, that sort of thing. And so doctors who were receiving these Title X funds brought a similar challenge, right? So the argument being that, well, sometimes in the course of providing healthcare, the question of termination comes up. And, if getting these funds is contingent on limiting what they say about that topic, then isn't this also an interference in their private speech, right? So you can draw an analogy here to physicians and lawyers, and that they have professional ethics codes that they're bound by. And in both cases, you have what we might call like a fiduciary responsibility between the professional and the client. The professional is bound by their code of ethics to act in the best service or in the best interest of their clients. And that's going to involve a certain amount of speech, right? Including on certain topics that the government may not endorse, right? So there might be cases in which both attorneys or doctors make recommendations that are contrary to the policies that the government in power at the time was promoting. So in this case, the court examined this question about Title X funding and quote unquote engaging in abortion related activities, and found that the regulations did not violate the First Amendment free speech rights for private clinics that receive Title X funds, their staffs, and it also, they said, did not violate the First Amendment rights of the patients to receive this information. The court found that this was not a viewpoint discrimination issue under the government speech doctrine, and rather emphasized that this was in fact government speech, right? And so because this was government speech, there was no requirement to avoid viewpoint discrimination. So the question I want to ask is, do you think that Rust versus Sullivan is consistent with Legal Services Corp versus Velasquez? As I mentioned in the last slide, Velasquez cites Rust versus Sullivan. But what do you think are the relevant differences? The next government speech case we'll look at is Pleasant Grove versus Sumum. So this is a 2009 case. This is an interesting case. So for those of you who are still looking for a case to present, this is a good possibility. It looks a lot like an Establishment Clause case because we are dealing here with a lot of the common elements that we see in public display cases, right? So we have public grounds or the grounds of a public building. We have a monument that in this case was commissioned by a private organization that presents itself as a religious organization. And we have other monuments already standing on this public ground, right? So this should all sound very familiar if you've looked at any of the public display cases. So the question here was whether or not the city of Pleasant Grove declining to put up this Sumum monument containing their quote unquote like 7 aphorisms, right? Which these are the principles of their religion. So whether this was an issue of viewpoint discrimination. So this is an interesting case because it ends up not being decided, as I said, as an Establishment Clause case, right? So if this were viewed as an Establishment Clause case, we would probably turn to the case Lynch versus Donnelly. So I realize it's a bit back in time now, but like if you think back to our Establishment Clause discussions, there was a case called Lynch versus Donnelly where the court asks whether or not having a display representing many different religions was permissible, right? So long as it wasn't showing viewpoint discrimination, it was okay to have some religious display on public land. A related case is the Allegheny County case. And in both of those cases, they end up being decided differently because of the question of whether or not, one religious viewpoint is getting more play or basically endorsement, right? It's called the endorsement test than the others. So this isn't decided on endorsement, but rather the court looks at this and says, well, was Pleasant Grove within its rights to reject this monument? And so the city explained that it differentiates between which monuments it takes and which ones it doesn't by saying that the ones that it accepts are, and I quote, directly related to the city's history, right? So this also, by the way, is a very common argument you see in establishment public display cases, that, there's a rich local historical tradition of whatever religious display taking place. The city of Pleasant Grove also says that the difference between, say, the Sumum monument and the other monuments that are displayed, including a Ten Commandments monument, is that these were donated by groups with quote unquote long-standing community ties. So they're making this argument that the length of time matters, right? So is it related to the city's history? Does the group have a long-standing set of community ties with the city? So the city rejected Sumum's request to have their monument erected in the public park, and they argued, again, not from establishment, but that the officials from Pleasant Grove had violated Sumum's First Amendment free speech rights by accepting the Ten Commandments monument, but rejecting Sumum's proposed monument. And so the argument that they make here is not, this isn't an endorsement test argument. Instead, they're saying this is viewpoint discrimination, which is inconsistent with basic First Amendment principles. They also argue that, look, this is a traditional public forum, and so you should be applying strict scrutiny to any government action that limits private citizens' free speech rights. So they invite the court to apply strict scrutiny. The court sort of like sidesteps all of this by saying, look, this isn't a matter of viewpoint discrimination because this is government speech. So in the next couple of slides, we will tease out how the government comes to this. So how the court comes to this conclusion. In Pleasant Grove versus Sumum, then the court holds that the placement of a permanent monument in a public park is a form of government speech, and therefore is not subject to strict scrutiny. So their argument is that the decision to either accept and place or reject and not place is sufficient to translate this into being a government speech case. So I will read a couple of passages from the decision that are important. They're here on the slide. So it says, because that clause restricts, this is the free speech clause, by the way, restricts government regulation of private speech, but not government speech, whether petitioners were engaging in their own expressive conduct or providing a forum for private speech determines which precedents govern here, right? So the question is whether or not, this is the government speaking in its own voice, or was this a case in which the government is establishing a forum, meaning the park, in which private entities are taking place, are engaging in expressive activity. So the important distinction here is that if the court had said, look, the government action at issue here is establishing the park and, allowing people to put monuments up in the park, then what we're looking at is a traditional public forum, and we have to apply strict scrutiny. But that is not what the court does, right? Instead, they say, no, actually, this is not a case in which the important government action is the establishment of a forum. This is a case in which the important government action is engaging in their own expressive conduct, right? Which is the government going to the effort of accepting this monument, right? Which is the first action they would take. So saying yes versus no, and then actually placing the monument in the park. So the government focuses on that action and says that, the court focuses on that action and says that's government speech. And because this is now the government speaking in its own voice, they are not bound by any kind of requirement of viewpoint neutrality. All right. Another key passage, a government entity is, quote, entitled to say what it wishes, right? So this comes from earlier cases, including Russ v. Sullivan. And it says, the government may exercise the same freedom when it receives private assistance for the purpose of delivering a government-controlled message, end quote. So the way they classify the action on the part of Sumum is not that Sumum is engaging in its own expressive activity by donating this monument, but rather that Sumum is offering to support the government in the government making a statement, right, which would be endorsing the 7 aphorisms. So there's a very kind of like fine distinction being drawn here. Again, the court does emphasize that if this had been treated as creating a public forum, it would have gone a completely different way, right? So the government does say, the court does say that the government is strictly limited in their ability to regulate private speech in quote unquote traditional public fora. That's the plural for forum. And so they say, okay, in that case, reasonable time, place, and manner restrictions are allowed. Content-based restrictions have to satisfy strict scrutiny, right? So narrowly tailored to serve a compelling state interest. To be clear again, they are not applying strict scrutiny in this case because they say this is not the government creating a public forum. They again also, right, reiterate that, look, if we were going to treat this as a public forum case, either a traditional public forum, we'd apply strict scrutiny, or a designated public forum, which arguably you could say a public park is, right, because it is a government created entity. And even in a designated public forum, the government is subject to certain restrictions on viewpoint neutrality, right? So the government is not allowed to discriminate between viewpoints in a designated public forum. But again, right, so when I say they're not allowed to, I mean they would be subject to strict scrutiny. But again, the court comes down and says, however, this is not one of these cases. This is not a public forum case. And here we have the key passage where the court outlines exactly why they're going to treat this not as a public forum case, not as an establishment clause case, but rather as a government speech case. So read this, think about the reasoning, and feel free to comment on the discussion board about what you think about this, like whether you find this persuasive or not, whether the distinctions that the court is drawing here are clear. So here's what the court says. Permanent monuments displayed on public property typically represent government speech. Governments have long used monuments to speak to the public. Thus, a government-commissioned and government-financed monument placed on public land constitutes government speech. Okay? So too are privately financed and donated monuments that the government accepts for public display on government land. While government entities regularly accept privately funded or donated monuments, their general practice has generally been one of selective receptivity. Okay, so I'm going to just take a step back here and point out this selective receptivity part. So the court is arguing that the decision to say yes or no to a monument, to accept it or not accept it, is government speech. All right, back to the quotation. Because city parks play an important role in defining the identity that a city projects to its residents and the outside world, cities take care in accepting donated monuments, selecting those that portray what the government decision makers view as appropriate for the place in question, based on aesthetics, history, and local culture. The accepted monuments are meant to convey and have the effect of conveying a government message and thus constitute government speech, end quote. All right, so the court is coming down in summum and saying that a government allowing a monument to be put in a public place is tantamount to government speech, right? So this is the government sending a message. Does this raise some questions for Confederate monuments? I mean, if we're going to take Pleasant Grove versus Summum at its word, then I have some questions about government decisions to continue to maintain Confederate monuments on government land. And there have been a couple of cases that have come up, not yet at the Supreme Court level, mostly at the state level, where there are municipalities saying, like, look, okay, fine, if this is government speech, then we would like to stop maintaining this monument or that monument. So I'll open a thread on the discussion board about this, and you can comment on that. So one of the things to ask is, was Summum decided rightly or wrongly? Right? Was this the case of the court, or was this a case of the court kind of dodging a maybe harder but more important question by punting to government speech? Or alternately, did the government open up a big can of worms here? Or did the court open up a big can of worms here by saying that accepting monuments on public land is government speech? One way that people have tried to thread this needle is by saying, well, there's a difference between putting up a new monument, right, the Summum monument, versus allowing a monument that has been there, for years and years and years to remain. How persuasive do you find that, right? Because there's still government action in maintaining these monuments. They don't just, keep themselves up. None of the monuments are going to, for instance, scrub the bird poop off themselves. Okay, so yeah, I look forward to seeing what you have to say about this in the discussion thread. All right, so the next government speech case we're going to look at is Walker versus Texas Division Sons of Confederate Veterans. This is a relatively recent case, right, 2015. So this dealt with vanity license plates, right? So personalized license plates. So the state of Texas offered a number of different license plate designs that were, some of them were, just sort of general messages, but some of them were also sponsored by private organizations that operated in the state of Texas. So for instance, there was a Ducks Unlimited plate. Okay, Ducks Unlimited, fine, totally inoffensive. I don't think anybody really has, a strong political vendetta against ducks. However, there was this other organization, right? So the Sons of Confederate Veterans, who wanted a pro-Confederate license plate option. Well, the state wasn't necessarily interested in doing that, right? So they found that this was offensive to many Texans, and they argue that they don't want to do this. They don't want to offer this license plate. Well, as you might expect, Sons of Confederate Veterans allege viewpoint discrimination, right? They say, look, sorry, like you're creating this platform for speech, right? You're letting Ducks Unlimited express their viewpoint. The government can't show viewpoint discrimination. So you have to let us have our pro-Confederate license plates. So the government responds to this by saying, well, no, actually, these plates are, produced by the government. There isn't another source you can go to, right? It's not like we have a competitor. So everybody who sees these license plates knows that they were produced by the state. And so actually these license plates are state speech. So take a look at the decision. It's in your book. Evaluate the reasoning given by the court. Number one, do you think that they sidestep the most important issues? And number two, what criteria do you think the government should use to decide which viewpoints to endorse and which to exclude? Right. So in this case, they're saying, no, we don't want to endorse, Confederate iconography. But we're fine with Ducks Unlimited. We're cool with, conservation. But, this Confederate symbol is controversial, and it isn't something that all members of our state are willing to accept. So no, right? Like we're not going to endorse that one. So what do you think the criteria should be? What criteria do you think that the criteria used in this case were the right ones? All right, so the last government speech case we're gonna look at is Mattal versus Tam. So this case came before the court in 2017. So this dealt with a band was operating in California. They were an Asian American group, and they called themselves the Slants, right? So if you're not aware, like this is an old racial slur that has long been used against people of Asian descent. So the idea behind Simon Tam and the rest of the Slants using this as their name was like an attempt to reappropriate the slur, essentially, right? To say like to kind of like disempower it by taking it back. Well, they went to register their name with the U.S. Trademark Office, and the office rejected their application. So they found that the name would likely be, and I quote, disparaging towards persons of Asian descent. And they cited the disparagement clause of the Lanham Act of 1946. Which prohibits trademarks that, and I quote, consist of or comprise immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons, living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute, end quote. All right, so this is an old law, right? The Lanham Act of 1946. The government has kind of had the option of applying it or not applying it in various cases. And in this one, the U.S. Trademark Office said, like, no, look, we're not gonna offer you a trademark for something that's a racial slur. So the Slants obviously challenge this, right? They say, this is like a really significant infringement on our freedom of expression, right? I mean, tell me that like a music group isn't at its core an expressive entity, and then their name, right? Their name is a really essential part of that expressive activity. So the Slants challenge this. They take it to the Supreme Court. The legal question raised by this case is, does the disparagement provision written by the Patents and Trademark Office violate free speech? So the court found 8-0. By the way, as an aside, sometimes you'll see these decisions that don't have 8 justices. There are a number of reasons why that might happen. Sometimes justices will recuse themselves if they have had previous experience with the case, say when they were sitting on the federal circuit before they were brought to the Supreme Court, or sometimes a justice is ill or it's in between appointments and the 9th justice hasn't yet been confirmed. But yes. So the court found 8-0 in favor of Tam, right? So Alito wrote for the majority, and he wrote, and I quote, "It is not easy to imagine how government could function, end quote, if it were subject to the restrictions that the First Amendment poses on private speech." So he reiterates that a government entity can engage in favoring its own particular viewpoint and rejecting other viewpoints when it's speaking in its own voice. So he says, and I quote, "The free speech clause does not require government to maintain viewpoint neutrality when its officers and employees speak about that venture," end quote. And so he says, nonetheless, while the government speech doctrine is important, it is also a doctrine that is susceptible to, as he says, dangerous misuse. And he says if private speech could be passed off as government speech simply by affixing a government seal of approval, government could silence or muffle the expression of disfavored viewpoints, end quote. And so Alito here cautions against overuse of the government speech doctrine, right? Because, I mean, arguably it was misused in Summum, right? I mean, depends on how you sort of like see that case, but it does leave this big, wide open loophole for the government to begin to reject speech that is unpopular, right? And if we recall way back at the beginning of our free speech discussion, Brandeis, cautions against the temptation to do that. So Alito acknowledges that this is actually like there's a slippery slope here with the government speech doctrine, and there has to be some kind of limit to it. So he goes on to say that it's far-fetched to suggest that the content of a registered trademark is government speech. And so he says that, if that were the case, the government would be, and I quote, babbling prodigiously and incoherently. And the reason for that being that all sorts of things are trademarked, right? All sorts of things that are not internally consistent with each other are trademarked. And so to think that all of the things that the government has trademarked, the government has somehow endorsed, is a stretch. It's a big stretch. And so he also says traditionally, trademarks have not been used to convey a government message. So like no reasonable person would think that every single thing that the government has trademarked is something that the government is promoting. So Kennedy concurs, right? And Ginsburg, Sotomayor, and Kagan join him. And he says that the test for viewpoint discrimination is whether, within the relevant subject category, the government has singled out a subset of messages for disfavor based on the views expressed. And he says that in this case, the disparagement clause that the government was at this point seeking to enforce identifies the relevant subject as, and I quote, persons living or dead, institutions, beliefs, or national symbols. So within that category, an applicant can register a positive or sort of like neutral mark, but not a derogatory one. And so he says the law thus reflects the government's disapproval of a subset of messages it finds offensive. This is the essence of viewpoint discrimination, he says. So this concurrence is important because we're going to see similar reasoning in RAV versus St. Paul. Actually, we do see similar reasoning in RAV versus St. Paul because that case came in time before Mittal versus Tam. But this is basically the idea of underbreadth, that the government can't pick and choose in prohibiting or punishing certain topics within a potentially prohibitable set, right? They can't say, some trademarks are okay, but not derogatory ones. The same way that, as we'll see in RAV versus St. Paul, they'll say it's fine to prohibit fighting words, but you can't just prohibit some fighting words. Okay. And that will conclude our discussion of Mittal versus Tam. So I'm just going to turn now to the idea of hate speech, because Mittal versus Tam is sometimes referred to as the most recent hate speech case that the court has heard. The reason it's referred to this way, again, isn't because hate speech is not protected by the First Amendment, because it is. The reason it's referred to that way is because it's the same kind of logic operating behind arguing for a hate speech exception. So as you'll recall, as I've said in earlier voice threads, the essence of hate speech is language that brings contempt, or sort of like libels, essentially, an entire group of people, right? And that group being defined on some immutable, visible, like identity-based characteristic. So traditionally, we see these groups being things like gender, race, ethnicity, potentially nationality, religion, right? So the things that are really core to someone's identity, that might be outwardly visible, and that historically have been important. So, for instance, no one can engage in hate speech against Democrats because that's just it's not the same kind of ascriptive characteristic. Okay, so Mittal versus Tam, as I said, is sometimes referred to as the most recent hate speech case. And as I keep trying to emphasize, there is no hate speech exception. So next we're going to turn to some things that are kind of like related to hate speech, and we'll discuss in a bit more detail why there is no hate speech exception, despite some other related policies being being accepted, like, say, for instance, hate crime sentence enhancements. You might ask why then we have things like hate crime ordinances in certain states and municipalities. Aren't these, an unconstitutional thing if we don't have hate speech as a category of exception under the First Amendment? Well, the court addresses this in Wisconsin versus Mitchell. This is a case from 1993. And so the court upholds hate crime ordinances and laws while still rejecting adopting the category of hate speech as a new category of exception. This rests, they say, on the distinction between conduct and speech. So conduct, they say, is punishable, speech is not. You might object to this saying, like, well, in both cases, what we're really looking to do is like reach to somebody's intentions, right? Punish their intentions. But the court says this isn't a problem, because if we look all over the criminal law, we see, sentences being increased because of people's intentions, right? So we, for instance, have this idea of mens rea, right, which is like knowledge or intent to do something that is wrong. And that in the criminal law is used to assess someone's culpability, right? So if you know that what you're doing is wrong, or if you intend to do something wrong, you are more culpable, right, or more blamable. So the court sees no inconsistency here in treating hate crimes, right, hate motivated crimes, as being, more heavily punishable than other kinds of crimes, while at the same time saying, no, you cannot punish or prohibit hate speech. In Virginia versus Black, I'm just going to briefly kind of preview this because this is an important companion case to the next case that we're going to look at, which is RAV versus St. Paul. So Virginia versus Black is an interesting case also because we also see some of these kind of blurry lines between conduct and speech and, hate motivated speech. So Virginia versus Black deals with a cross-burning case, right? So does RAV, which we're going to talk about in just a second. Virginia versus Black comes after RAV, and also obviously after Wisconsin versus Mitchell. So this dealt with a cross-burning case. And I'm not going to go into all of the details, but what this dealt with was a state law that allowed courts to interpret cross-burning as a true threat, right? So I want to make clear, however, that they carved this exception out specifically for cross-burning only, right? So if it had been anything else being burnt, if it had been a swastika flag, it would have been different. But the court says in Virginia versus Black that because the United States has the history that it does, right? We have the history of race-based chattel slavery. We have the history of Jim Crow, of segregation, and of this, like, these decades and decades of coordinated racial terror, specifically targeted against African Americans. And because we have this history, and because the symbol of the burning cross is so intimately tied up with that particular history, they make an exception, essentially, for treating a burning cross as constituting in and of itself a true threat. So we'll talk a little bit more about true threats in just a moment, but true threats are another area of exception under the First Amendment, right? So they are not protected by the First Amendment. You can't go around making threats against people and then say, oh, well, I was just exercising my freedom of speech. You can't punish me, because this is punishable speech. And so this is the one exception the court has made to defining true threats as having to have, verbal elements that specify a target and then specifically, state what action is going to be taken against that target. So I think this is an interesting area of the law. This is a case we occasionally see the court kind of step outside of these sort of like rigid typology kinds of like ways of reasoning and look kind of like more sensitively maybe at like history and context, right? So this is another one of these cases. I would compare this actually kind of to like Lynch versus Donnelly, where they look at the context of the thing and say, okay, just because of the particular history of the United States, this thing means something different. Okay, and so what they find in Virginia versus Black is that burning a cross can reasonably be interpreted as being a true threat. All right, so now we're going to look at RAV versus St. Paul, which is the last kind of like hate speech related case that we're going to look at. So this is a case from 1992. And it was looking at the question of whether or not the St. Paul, Minnesota bias motivated crime ordinance was on its face violating the First Amendment. So the question here is whether or not this is viewpoint discrimination, right? So that's ultimately where the court goes. But there are a lot of pieces to this case. So first thing, this seems like a weird name. Why RAV versus St. Paul? Well, because RAV was a minor. And when the person who's involved in a criminal act specifically is a minor, the court will not, publish their entire name. They just treat them, or they just address them by initials. So ultimately, in this case, the court invalidated the St. Paul bias motivated crime ordinance. So it read in part, whoever places on public or private property a symbol, object, appellation, characterization, or graffiti, including but not limited to a burning cross or Nazi swastika, which one knows or has reasonable grounds to know arouses anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender, commits disorderly conduct and shall be guilty of a misdemeanor. Okay, so there's a lot going on, even in just this little paragraph. First of all, let's look at terminology. What's an appellation? Okay, well, it's a name, right? So this would be something like what they're getting at here is a racial slur. Characterization, this might be like a racist depiction of, a racist or stereotyped or both depiction of a person. And then graffiti. So one of the reasons why this ended up being such a First Amendment issue is that if you look at the language of this ordinance, it specifically targets expression, right? There's no way you can say that, an appellation, right, a name, that's written words. Characterization, right, that's going to be some kind of depiction. Same with graffiti. There's no way you can say those things are not expression. The next issue is that it specifies certain things, right? So the burning cross and Nazi swastika language is not necessarily a problem because these are examples, right? This isn't giving the full set of things that will be punished versus others. But the next issue is on the basis of race, color, creed, religion, or gender. So it's specifically targeting expression. That's the first problem. This becomes a problem, right? This set of biases becomes a problem because, again, we're not dealing with action, right? This isn't a hate crime ordinance. We're dealing with speech. And so prohibiting speech that, is defamatory on the basis of race, color, creed, religion or gender gives us just a small set of what might otherwise be considered fighting words that will be punished when other kinds of fighting words, for instance, wouldn't be. There's another issue with this term that they commit disorderly conduct. Okay, so this part of the ordinance translates expression, right? So again, characterizations or graffiti or appellations, this is all expression being translated through this statute into conduct, right? And so the court also does not support that. All right, so if you're feeling a little confused about what's going on in RAV versus St. Paul, here is a breakdown, basically on the slide of all of the things that I just kind of foreshadowed in the last slide. So these are all of the various problems that the court identifies with the language of the statute. Here we see the appearance of this term under-inclusiveness. This is sometimes referred to as quote-unquote underbreadth. I think that's kind of confusing though, because it seems then like it's related to the concept of overbreadth, right? So overbreadth is one reason why a statute might be struck down on its face as being, a violation of the First Amendment, or why certain parts of a statute might be struck. This is not actually really that closely related to the idea of overbreadth. The under-inclusiveness problem with RAV is best understood as a viewpoint discrimination problem. They say it's quote unquote under-inclusive because it specifies only certain cases of fighting words as being punishable. And the court says, no, like, look, when you're taking a whole area of speech that's not protected and saying like, look, we're going to punish this That's fine. That's not a constitutional problem. The problem emerges when instead of taking that whole category, you're going to say like, okay, well, certain kinds of fighting words we're going to punish. And the problem there with specifying the kinds of fighting words is that specification is going to take place on the basis of some kind of viewpoint being promoted and another viewpoint being, suppressed. And so the court says, no, this is actually viewpoint discrimination. You can't do this with your bias motivated speech ordinance. All right, so here again is this explanation of underbreadth or under-inclusivity. So this is specifically something that Scalia points out, right? So he likens this to the government requiring that, certain viewpoints fight with one hand tied behind their back, right? While the other viewpoints, don't have to. So, whether you think RAV was decided rightly or not, we can discuss on the discussion board. But the way that it's distinguished from other cases, for instance, Wisconsin versus Mitchell, is this conduct speech distinction. And also, I think it's interesting to compare RAV to Virginia versus Black, because they're both cross-burning cases. And in both cases, the court does acknowledge, right, that cross-burning has this particular connotation that goes with it. But also, we see in RAV a very strong reiteration that the government is not going to create a hate speech category of exception. All right, so taking a couple of steps back, now that you've seen, Wisconsin versus Mitchell, Virginia versus Black, and RAV versus St. Paul, I'm going to say a little bit more about true threats, right? So I've mentioned true threats as being an area of speech that is not protected by the First Amendment. And that is the case. This is a category of exception. So the test for true threats is set by this case Watts versus United States, right? And so this was, surprise, surprise, a case that came before the court during the Vietnam War. And an 18-year-old man named Robert Watts says, and I quote, "If they ever make me carry a rifle, the first man I want to get in my sights is LBJ," right? So he says this at a political rally. And he is then, arrested for threatening the president. So again, by way of context, when he says make me carry a rifle, he means if I'm going to be conscripted to fight in the Vietnam War. He says the first man he wants to get in his sights is the president. Now, it's important to note to where this speech takes place. So the court is going to consider all the context when they look at a true threat question. This was a political rally, right? So at a political rally, it is more likely that Watts is engaging in something more like political rhetoric or hyperbole even than a true threat against LBJ, right? Especially because, Johnson wasn't present. So he was convicted of knowingly and willfully threatening the president. But the Supreme Court found that the statute that he was convicted under was constitutional, right? So the statute that prohibited making true threats was constitutional, so they don't strike down the statute. They do, however, say that it was unconstitutional as applied. So I've made this distinction before. This is the difference between a facial challenge and an as-applied challenge. In this case, the problem wasn't necessarily the statute, right? The statute that punishes making true threats. However, the way that statute was applied was found to be unconstitutional. So they reversed Watts's conviction and established that true threats are an exception to free speech. But they also emphasized that the statement has to be viewed in its situational context, right? So true threats are not the same thing as hyperbole. They aren't the same thing as satire. A true threat has to specify a particular target, and they have to also specify a particular action, which actually, if we look at this, he kind of does, right? So who's the target? Well, Lyndon Baines Johnson. And what is the action that's being threatened specifically? I mean, he doesn't say like outright, I'm going to shoot him, but he does say, if I'm carrying a rifle, the first person I'm going to get in my sights is LBJ. That's fair. All right. So as I was saying, it's fairly clear that, Watts was, he does actually sort of specify the target and the action. But if you look at the context, this was at a political rally. And so, he's addressing a crowd. The crowd is, angry about the war and angry about the draft. And this, in that context, is not actually a statement of intent to do harm. It is political rhetoric, right? It's hyperbole. All right, so now all of that being said, right, we've seen RAV versus St. Paul. We've seen, the viewpoint discrimination issue. We've seen the speech action distinction in Wisconsin versus Mitchell. We're now going to revisit Virginia versus Black, right? Just very briefly. So this is the case I was talking about, wherein the court decided that cross burning can, in fact, constitutionally be interpreted as a true threat. And so the issue with this, it's a bit of a complicated case, actually, because the statute construed cross burning as a threat, right? Just sort of automatically. And so the court said, well, okay, you can't construe cross burning as a threat in any and all cases. You have to consider the context, right? So, for instance, if you were making a movie that included a cross burning, then, while you're shooting that, you aren't actually making a threat against somebody. Similarly, right, if there's like a controlled burn of an old church, right, then, the whole building is burning and also maybe the cross on the top. Obviously, looking at the context, that's not a true threat. However, most cases in which the court is likely to encounter a burning cross, right, or a person, like a citizen, is likely to encounter a burning cross, is going to be a threatening context. So yes, crosses, they say, are different. This is a special kind of communication that is generally in and of itself a true threat, right? Even though they don't have that verbal piece. So O'Connor says, and I quote, "Intimidation in the constitutionally proscribable sense of the word is a type of true threat, where a speaker directs a threat to a person or a group of persons with the intent of placing the victim in fear of bodily harm or death," end quote. So while we get the true threat definition from Watts, actually O'Connor here really very, I think, succinctly and completely summarizes what a true threat is, right? And what the purpose of having this as a quote unquote prescribable type of speech is. All right, so that concludes our discussion of government speech and also of hate speech. I'll make a little bit more reference to hate speech when we look at Hustler Magazine versus Falwell, just because, the language from Shaplinsky, remember going back to fighting words, that language of words that, simply by their very utterance inherently inflict harm, that is dropped by the time we get to Cohen, and the kind of final nail in that coffin is Hustler Magazine versus Falwell. All right, so I look forward to your opinions on the discussion board about RAV, about government speech, right? So we've got a couple of really interesting, pretty controversial cases to discuss.